Okay. Well, welcome everyone. My name is Celia Chandler. I'm a lawyer at Iler Campbell, and I'm really excited to be kicking off the first of our 5 webinar series in September to mark the return to school. I know there's been a lot of focus on schools right now, and so this we thought would be a nice safe option for everyone to get a bit of legal education and not have to leave their homes or their offices. So before we start the topic today, which is of course wills, I want to acknowledge the land that I'm sitting on today. As many of us are settlers on this land, we pay respect to and recognize that this land is the land of the Ojibwe, the Anishinaabe, and in particular the Mississaugas of the New Credit, whose territory I'm sitting on here in Toronto today. This territory is covered by the Upper Canada Treaties. The recognition of the history, contributions, and importance of Indigenous peoples must be connected to our collective commitment to make the promises and challenges of truth and reconciliation real in our communities. So today's topic, where there's a will, there's a way forward, has a number of whoops. Why is my computer not responding to me? There we are. It has a number of bases. Why are we having this session now? Well, first, I think many of you who are familiar with our firm might not, in fact, have realized that we even do wills. It's been a part of Iler Campbell for many, many years now. We've largely done wills for people who work and live in the sector that we predominantly serve, which of course, as most of you will know, is the nonprofit, charitable, and co-op sector. I'll tell you, I'm fairly new to doing wills, and I guess it's not a secret. Most of you will know, or those of you who know me will know that my husband died about 1.5 years ago. And so not only did I have to go through the process of will drafting with him, I was also executor in his will. And of course, I got a new appreciation, I guess, for why it's important to have a will and why it's important to know if you're going to be an executor, what that entails. So that's why I'm doing this session. And then I guess people have joined today, my guess is, because we are all getting older every day and therefore getting closer to a time when we might be thinking we would die. But we're also living through a time when people who didn't expect to get sick are getting sick. And we're also living through a time when we're spending a lot more time perhaps at home, and we might be getting caught up on some things that have been on our list of things to do for a while, but we haven't gotten around to them. So I think, for all of these good reasons, we thought a session on wills, a very introductory session on wills, might be a good thing to have today. So I'm going to answer 6 questions today, very briefly and at a fairly high level. And the questions are listed there. And then I'm going to give you some links at the end to some other resources. Of course, we only have an hour together. And so this really will be quite an introductory session. But I hope it will help you understand if you have a will and you haven't updated it for a while, why you might want to do that. And if you don't have a will, why it would be important for you to get one, and what some of the important considerations would be in that process. So, as is always the case, when you listen to or watch a webinar put on by a lawyer, it's legal information that's being passed along. It's not legal advice. So if you need legal advice, if you need a will to be drafted, if you need a will to be reviewed, then that's the time to talk to a lawyer and talk about the specifics of your situation. And that's not going to happen today. So just want to make that really clear. So 6 questions, let's start. The first question that I thought some of you might have is, why do I need a will? So a will, for those of you, I'm sure everyone understands what a will is, but just to clarify, it's a written document that gives some information for what you want to have happen when you die. And the most important, it's a very important document because it provides the legal instructions to the people around you for what happens when you die. And I guess the most critical question it answers is, what did you want to have happen to your things? So, most people when they die will have some items, some personal possessions. Most people will have at least a bit of money, and some people will also have some real estate, so some property that they own. And there may be other things that you leave. Like if you're a writer, you might have some things that you've written that you have a particular interest in having dealt with the way you'd like. You might have some pets. You might, there's a whole range of things that we own that need to be dealt with in some way when we die. And the will is the document that will explain to whoever's left behind what it is you'd like to have happen to those. So that then also means that the will has to say who's going to get those things. So, many of us leave possessions or money to people in our families, or maybe some close friends, people who've helped us over the years, particularly if we've been ill, then, we might leave money to people who've been helpful during that period, and so on. There are people who either don't have loved ones like that, who are people they want to leave money to, who prefer, in fact, to give money to charities or other organizations that they believe are doing important work for causes that those people believe in. So, and many people have a will that provides some money to people and some money to charities, and sort of reflecting their wishes in that way. Sometimes there may be people in your life who you want to not get anything. And one of the consequences of having a will is that you can ensure that, to the best of your ability, those people do not benefit from your death. Sometimes we have family members that haven't been particularly helpful to us, or what have you, and we want to make sure that they don't benefit when we die. And then the other important thing that needs to be set out, written down in a will, is who is the one who's going to carry out all of your instructions. So that's the person who's usually called the executor or the trustee for your will. And so in a will, you have to say who's going to be the one to carry out your instructions. And that's a critical piece of the will making process. And we'll talk a bit more about what kinds of things you should be thinking about when you're assigning the role of executor to somebody. I always recommend, when I'm talking to people when they're writing a will, that they also have something that I kind of refer to as a death binder. It's sort of it's not meant to be funny. There's nothing particularly funny about any of this, but a death binder is just the place where I put all the information that my executor will need when I die. And so I'm sure some of you are thinking, well, surely all that information would be available on my computer and so on. I actually recommend physically having a binder that has copies of bank statements, investment statements, information about lawyers or investment advisors and so on, who all of whom might be involved when I die, and that's information, therefore, that the executor will need to get access to. And leaving it on a computer, I can tell you from my own experience, sometimes you forget to get computer passwords before somebody dies. And so if all that information is locked up on a computer, but you don't have access to that computer, it's not much use to you. So a physical binder is I think, a pretty important part of, and sorry about that, a pretty important part of leaving a paper trail for your executor so that person is ready when you die. And I update my death binder every year when I'm doing my taxes. It's just part of my process. So if things have changed, if investments have changed, if I've changed banks, if other things have happened in my life, then I make sure I make sure that that's all up to date at the time of my tax filing, which it happens once a year, whether we like it or not. So that's, I think, those are the main points around why a person needs a will. Next question, I'm sure you're asking, is, well, why do I need do I need a lawyer to prepare my will? And the short answer is no, not necessarily. So there are a couple of other options. Obviously, I wouldn't be a good lawyer. I wouldn't be a good business person if I didn't say we don't really recommend these other options. We recommend that you use a lawyer rather to prepare your will. But there are two other options. One is called a holograph will, and that is a document that you write in your handwriting, and it has to all be in your handwriting, which states, who your executor is going to be, where you want your stuff to go when you die. And so long as you sign that and date it, that can be a legal will. And you should, if that's the option you're taking, you should look at one of the links I have at the end to make sure you're fulfilling all the requirements for a proper legal holograph will. The other option is to buy a will kit, and I think you can get kits rather for all sorts of legal processes. You can get divorce kits and so on, and these are just they're intended to help you do these things on your own. I've actually never looked at a will kit, but I know there's lots of people who've used those. And that might be something you would decide to use as well. However, I think there are some advantages to using a lawyer, and obviously I'm going to say that. But I think you can assure yourself that if you're using a lawyer, you're paying for the expertise that lawyer provides to write the language in the language of the courts. Where a will can sometimes end up after somebody dies, and in the language, therefore, that will explain what you wanted to have happen when you die. But there's more to the lawyer's role than just writing the document. Sometimes you will have indicated that you want to make some decisions around where your stuff should be distributed after you die. And the lawyer will say, there may be a challenge to that. And have you thought about the fact that, your decision might be something that person is going, or some person is going to dispute. And let's figure out how we can avoid that dispute being a successful one. You also, when you make a will, you have to have the mental capacity to make a will, and in order for that will to be legal. And sometimes when you work with a lawyer, that lawyer will be able to identify a possible problem with the mental capacity of the person making the will. And that's part of the role of a lawyer in a will-making process. Certainly, a lawyer is there to answer any questions you have about how to make it the easiest it can be and the less expensive for your executor to deal with when you die. And that is certainly an important role for a lawyer to take on. I know that many clients come with questions about how to choose an executor or what we call a POA, and we're going to talk more about what a POA is, a power of attorney, and we are certainly available to answer questions about how you would go about choosing those people. And then sometimes a person who's making a will have chosen to use a trust company, either as an executor or as a power of attorney. And when you work with a lawyer, there's usually a bit of back and forth between the lawyer and the trust company on what language needs to be included in the will in order to satisfy their requirements at their end. So these are all some of the very good reasons, I think, for why you might want to work with a lawyer on the process of drafting a will, and but certainly it's not necessary. Okay, so question number 3. So I've made a couple of references now to powers of attorney. So I want to explain a bit about what they are and the 2 different types of powers of attorney that you will probably want to have. And these documents, the documents that identify who the powers of attorney will be, are also documents that often get prepared when you're preparing a will. So a POA, a power of attorney, is a document that may be necessary before you die. It has no value after you die. At the point when a person dies, the will is the document that takes over. But the powers of attorney documents are important in the event that you can no longer make decisions for yourself for whatever reason in a period before you die. So there are 2 different kinds of powers of attorney documents. One is a power of attorney for personal care, and the other is a power of attorney for property. So the first one, power of attorney for personal care, is a document that identifies who's going to make decisions about your care when you cannot make those decisions. So, many of us, when we age, unfortunately, one of the things that sometimes can happen is that we will lose some mental capacity. And there comes a point where we can no longer decide whether we should be living at home or living in a care facility, for example. And the person that you identify as a power of attorney for personal care would then have the right to make those decisions about your care. Or another example, sometimes, you might have some kind of catastrophic injury, which would put you in hospital and maybe in the ICU. Perhaps you're in a coma, and there need to be decisions made about whether there will be life support given to you or other things of that nature. And the person that you've identified as your POA for personal care is going to have to make those tough decisions. It doesn't have to be one person. Sometimes, for example, in a situation where someone is a parent to 3 or 4 children, then they might identify that all of those children have to come to agreement on making those decisions. So that's the POA for personal care. The power of attorney for property is a similar kind of document where you identify someone who's going to make decisions about your money and your property. Pardon me. And that document can, depending on how it's worded, can apply at any time, or it can apply only when you are no longer capable of making those decisions for yourself. So again, it's important that you recognize that there may be times when you're not in a position to any longer make those decisions. And it's a valuable process to go about identifying who should make those decisions for you. So question number 4. What should I consider in a will and in power of attorney documents? So we talked a little bit about the fact that you need to identify in your will an executor, a trustee. And we've also now talked about how you need to, when you're going through this process, you will probably want to also identify who will be your powers of attorney for personal care and for property. So many people identify the same person in each of the 3 roles, and that's often the case. For example, if you have a spouse, you will identify your spouse as your executor and as your power of attorney for personal care and as your power of attorney for property. And often in a case, if 2 spouses come to us to have wills and power of attorney documents prepared, they will identify each other in those 3 roles. But then I always say to them, well, one of you gets the privilege of being the executor to the other one, but the other one will have to find a backup. We'll have to have a backup in place to be the executor. Because, of course, the first spouse dies, you can't then play the role of executor to the second spouse. So not only do you need to come prepared to identify an executor and powers of attorney, you need to also come prepared to identify backups for all of those 3 roles. And sometimes that can be a little trickier for people. They maybe haven't thought through who else in their life they would entrust with those important roles. And so some things that you might consider, is someone trustworthy? Do you trust them with money, for example, or do you trust that they would exercise good judgment in making decisions about your care or your money in the case of the power of attorney? Or do you trust that they will properly fulfill the role of executor in the way that you would expect them to if you've died? So that's the first attribute I think you want to look for, is somebody who's trustworthy. Are they skilled? So, you may trust them, but they don't actually have a very good way of managing paper, or they don't have a good way of managing money. Maybe they don't have great English language skills, so they might have trouble finding their way through the banking system or the court system if they had to go to court as an executor. Like, all of these things you would need to consider as you were appointing people to these roles. Are they available? And that's a really big one. Somebody recently told me that, warned me that being an executor is a heck of a lot of work, and that during that process of being an executor to a will, you might actually lose quite a bit of affection for the person who died, because it is a lot of work, and you're it's the last opportunity to clean up any mess that person might have made in their financial life or in their legal life in other ways. So it requires a lot of time in many cases, and then it also requires access to offices and so on, where it might be really important. I think it is really important that your executor and your powers of attorney live in the same city as you or the same town, so that you can, or have easy access to those, so that your affairs can be handled in an efficient way. The other aspect of availability that you should consider when you're selecting executor and powers of attorney is this person likely to still be alive, right? Like, there's no point in appointing your aging parent as your executor if they are going to die first. And so, it's a good chance to think about what younger people you have in your life you plan to have an ongoing relationship with, and who, of course, have the other attributes that you would want for someone in the roles of executor and powers of attorney. I think, people like myself who don't have children have to be a bit more creative, but usually there are some people around who could play that role. And then the last point, which I think is a really important one, is the person that you've identified for one or more of these roles actually willing to do it? I think it's an important role to take on. It does take up a lot of time, as I've said, and therefore it really is the sort of role that you want to assign only after you've had a serious conversation with the person about it. It's not something you want to spring on them after you've died. So sometimes you might, at the end of that process, identify the person you think is perfect and then discover they don't want to do it, or not have anyone that really meets the criteria. And then you would probably be looking for a trust company who would be willing to play the roles, at least of executor and power of attorney for personal care, or for property rather. And of course, they are they're going to want to be paid for that role in a way that's more than likely more than what an executor or power of attorney would typically take as fees. There are opportunities to take fees in these roles, and many people, when they're writing their wills, will include a paragraph in their will, for example, that says the executor should take whatever fees they're entitled to. But for a trust company, that might be more. That's likely to be more. So that's always one big piece that we discuss when someone comes to me to prepare a will and a power of attorney, is who they're going to put into those important roles. Another piece that often people writing wills or having us write wills will want to be sure is covered off is how that person's dependents are going to be cared for. So oftentimes people who've recently had a baby will suddenly be interested in having a will, because suddenly they want to be sure that the care of that child is covered off in a document, and covered off in a way that they've thought about carefully and want to, and have considered the best person or people to look after that child. Sometimes people have other kinds of dependents in their life, siblings or adult children who need ongoing care. And all of that needs to be addressed in a will. Don't forget, in some cases, you have pets that need ongoing care. I've never had one of these, but I understand people who own parrots have to spend time thinking about who's going to look after their parrot, because they will outlive parrot owners. And so that kind of thing has to be included in a will, or might be included in a will depending on the person's circumstances. And then one other consideration that I thought was worth mentioning today is making sure that what you believe you're going to have at the time you die is greater than what you are allocating to your loved ones. So, for example, a person in their middle age might have, let's say, $200,000 savings. I'm just using that as an example. And so they come to a lawyer and they say, okay, so I have 3 children and a niece that I really care about. So I'm going to say that each one of them is going to get $50,000, and that's 50 times 4 is 200,000. So that's all the money gone. So that that might seem like it would make sense if that person died tomorrow, but of course, between now and that time the person dies, they might increase the amount of money that they have, but they might also have to start using the money that they've saved in order to live. So at the end of a person's life, they might have considerably less than the money that they had when they wrote their will. So there are ways that you can write the will to make sure that whatever money is left over is divided equally between certain people, as opposed to assigning dollar amounts. But part of a lawyer's job is to make sure that these things kind of make sense, and are dependent on a person dying at any particular time. So that's there are many other considerations for what should go in a will, but those are a few of the ones that seem to come up from time to time in the work that we do. Certainly, the choice of executor and POA is a biggie, and often not something that people have given a lot of thought to before they actually start talking to a lawyer. So, before you talk to a lawyer, you should really think through some of that, if that's the road you're planning to go down. So, question 5. What happens if I die without a will? So I know you're all joining us today, and therefore that suggests to me that you might be thinking you're going to draft a will. But let's talk about what some of the consequences of not having a will might be. So first off, it means you won't have identified an executor. So this, there's a whole process to go to court to have an executor appointed by the court. And that's going to depend on someone, wanting the job, going through the court application. And that person may be someone that you don't really want to have doing that. Maybe they're not particular. They haven't met those criteria that I talked about a minute ago about being trustworthy and skilled and available and so on. And maybe they don't want to do it, but they've sort of reluctantly, it's thrust upon them. Maybe it's not a particularly practical role for them to have. Like maybe, they're an aging parent and they're in a retirement home and they're not really able to get out and do the things that would be required of an executor, and so on. So that's one big problem if you die without a will. Another big problem is that you haven't identified who your beneficiaries are going to be if there's no will. And so we have a piece of legislation that will deal with that would say who gets what if somebody dies without a will. But those might be, the Succession Law Reform Act is the name of that document, or that piece of legislation. And it might assign things to people that you don't want to have your things going to, your money going to. And it might exclude the people that you would prefer would benefit at your death. It depends on the circumstances of a person as to who would get that money. But, sometimes the money would be distributed to your parents, for example, if they're still alive. But you would really much rather that money gets distributed to your nieces and nephews, because, typically younger people are in greater need for money. That's a huge generalization. But you see what I'm getting at. If you haven't said what you want to have happen, then there's a reasonably good chance that what you want to have happen is not going to happen. It's not going to happen. If you die without a will, that you may end up leaving people fighting over things after you die. People don't always behave well, and even when there is a will, sometimes there can be fights. But at least there's a better sense of what you as the deceased person wanted to have happen, and that when there's a will, and that might stop some of the fighting from happening. Another consequence that, what do you care really? At this point, you'll be dead. But there may, I know that many of our clients are housing providers, so we often get consulted by those housing providers about what to do in the case of a member or a tenant dying and not leaving a will. And suddenly it is your housing provider's problem to figure out how to deal with your things and so on. And that's a bit unfair to them. It's very time consuming and so on. And it could have been avoided if you'd indicated something in a will. And again, it doesn't have to be a complicated will. It just needs to exist. So I'm going to move now to the last question on my list. So let's assume that you have a will, and the question is, when should you change your will? So I know, lots of people, for example, might have written their will at the time they had their first child, but now their first child has just had her first child, for example. So that will is pretty old. And maybe it doesn't even reflect the fact that there's more than one child now. So, my parents wrote their will when they had 4 children, and then 8 years later I was born. And they didn't update the will to reflect my existence for, I think, another 15 years. So, that happens. And that is probably not the end of the world. Nobody died in that case, so it didn't really matter. But generally, you should think about changing your will when significant things happen in your life. So, first thing, of course, that might prompt you to change your will is when someone important in your life has died, and in particular, when your executor has died, or when your spouse has died and that person was going to be your beneficiary. So, that's a good time to think about making a new will. Next significant change, when somebody's born. So I've already mentioned that often parents come to us having had their first child, and they decide, okay, I'm going to change my will now, but they don't often then change it for subsequent births. And if the will is written to be general enough to include other children, then that's fine. But it may be important to update as other children are born. People with small children will include sections in their will about how they want their small children to, who they want their guardians to be, how they want them to be raised, maybe where they want to be raised, and so on. When those children grow up, that information in the will no longer be relevant, so it might be time to change the will. You might have lost touch with people in your life, possibly people who were identified as executors or powers of attorney. If you're no longer in touch with those people, then it's probably not a great role for them to have. It may be, you've got family members that you're not close with anymore that you would no longer want to benefit from your death or play a role like executor or power of attorney. When you move to another city, or town, that may also be a time to change your will, particularly if you've identified an executor and powers of attorney in the location you were originally. Then, of course, you would want to make sure that you get people to replace that who can act locally in the event that you need to rely on the power of attorney or at the time that you die. And then I've already addressed this last point a little bit, but just to kind of hammer the point home, if your primary executor or even your backup or primary power of attorney or the backup have either died or have become incapable of taking those roles on, then you'll want to update your will in order to replace them with someone who's in a position to carry out your wishes. And then the last point on this slide, you may not know this, but if you have recently married and you had a will before, then there's a pretty good chance that will has been automatically revoked by your marriage. I guess the thinking is that when we get married, we might change the way we distribute our money to include our new spouse. So, it may be that your prior will was worded in such a way to allow it to continue if you got married, but you'd need to talk to your lawyer and make sure that you haven't inadvertently put yourself in a position of not having a valid will at all. That's just sort of a weird little fact, but worth knowing if you're in that position. So I'm wondering now whether we should just pause and take some questions. I see that we've had one, and the question is, what is the typical timeline for obtaining probate, and has COVID-19 slowed down the process of probate? So I haven't talked at all about probate today, but let me just explain it at a really general level for those who might not be familiar with that term. So the probate is a court process, and if after someone dies, there are assets in their will for which you need to prove that the person who died was the owner of those assets, then there is a process to apply to court to have the to authorize the executor to deal with those items. That's probably the simplest way of explaining that. And that process is called probate. And when you have to probate a will, you also have to pay into the court a portion of the estate, and it's dependent on the size of the estate, how much has to be paid as a tax on that. So oftentimes when people come to us to have wills prepared, they are looking for ways to structure their assets, the ownership of their things, so that the probate can either be avoided entirely, or the amount that would be owing as probate fees would be as low as possible. So that's in a nutshell what probate is all about. And the question is, what's the typical timeline for obtaining probate? Has the COVID-19 slowed the process down? Short answer is typical timeline varies a lot depending on what jurisdiction you're in. The Toronto Estates Court is notoriously slow, and part of that is because they are very, very, very picky and detail oriented. So they will reject your probate application for like a missing comma, or something else that seems extremely minor. And so that inevitably delays the process. We actually have not filed any probate applications in the last 6 months. So I don't know the impact of COVID-19, but I would say it will have most definitely slowed everything down, because I believe that even the estates court was closed, like even the administrative side of the estates court was closed. I don't know if they were working from home or not. So I'm sorry, Carol, and thank you for the question. I don't know the answer to that side of it. Sorry about that. So I'm hoping there are more questions coming. But in the meantime, let me just point you in the direction of a few other resources. The Attorney General's website has some really excellent documents that are quite user-friendly around powers of attorney documents and around wills. I mentioned the Succession Law Reform Act, which is a piece of provincial legislation which talks about, where your money would go if you didn't have a will and so on. So that may be another document that you want to take a look at. And that is about it for resources that I can identify. We, as many of you will know, and presumably lots of you learned about this webinar from our blog. We do blog about issues, legal issues, and occasionally we'll blog about wills issues. And so that's another resource that you may already be signed up for, but if not, you should check out our website and sign on. Unless there are other questions, which I don't see, we still got another 10 minutes or so, I will do a quick plug on the remaining seminar or webinars in this series, our Back to School series. Next week, my colleague Claudia Pedrero will do an hour-long session on how to co-own property with other people. I know lots of people have seen this as a viable option, both as a way to kind of beat the rising cost of real estate, especially in cities like Toronto, but also as a way to develop community and feel a bit of a sense of that in your own home. So lots of people have come to us to help them with co-ownership agreements, because obviously you want to be sure you've got the rules hammered out in advance, because sometimes disputes can arise. So you want to know how you're going to redress those. And Claudia's had lots of experience working on drafting those co-ownership agreements. And I think you'll find that will be a very interesting session. And I should say that although this is not really pitched as a COVID series, at least not entirely, the co-ownership model, I know lots of people have been wanting to get out of their downtown towers and move to suburban or inner suburb communities where the cost of real estate is still kind of unaffordable for many. Co-ownership is a way maybe of getting around that. So check out Claudia's session next week. Then Michael, in 2 weeks' time, is going to talk about some unionized workplace issues, although most of our clients are charities, nonprofits, and co-ops, and only a relatively small number of those are unionized environments. Michael has worked with many which are unionized on issues related to COVID and other union workplace issues. So he's going to address that for an hour on September 16th. Then Carly Wilson, our newest lawyer at the firm, is going to talk on the 23rd about how the Landlord and Tenant Board is working in this post-pandemic or post-lockdown world. As those of you in the housing world will know, the LTB, the Landlord and Tenant Board, is up and running again, but in a kind of modified way. So Carly's going to give some insight on that. And then finally, the last Wednesday of the month, our colleague Celia Chandler is going to talk about returning to work in non-union environments, which of course is most of our client base, and some considerations for employers. So I think that's more or less all I had to say. I'm still seeing no other questions. So unless you've got anything burning to ask me, we'll say goodbye. And thank you so much for joining us. I hope that there was something useful in what I said today. If you need help with the will, obviously we're available. You just need to be in touch, and we'll set you up as a client and get working on that for you. So thanks again. Have a good day, everyone.